Everybody, good afternoon and happy Friday. I'm Perry Turner, a Deputy County Administrator for Justice and Safety, Office of County Administration. I'd like to welcome you to the O'Donnell Consent Decree public meeting. For those of you that are new here, the O'Donnell Consent Decree was created following a class action lawsuit against Harris County from plaintiff Miranda O'Donnell, claiming that the bail system was unconstitutional. Specifically, O'Donnell reported that after being arrested for driving with an invalid license, she was detained in Harris County Jail because she could not afford to pay her $2,500 bail. The parties involved in this lawsuit reached a settlement agreement known as the O'Donnell Consent Decree. We all recognize that it takes a whole of society approach to ensure fairness and equity in our criminal justice system. We encourage your support in the ongoing monitoring and evaluation of our system here in Harris County. As a result of the consent decree, public meetings will occur every 6 months. Today, independent court monitor Professor Brandon Garrett, Deputy Monitor Professor Sandra Garrett-Thompson, and representatives of the Harris County Attorney's Office, Sheriff's Office, and presiding judge of the Criminal Courts of Law will discuss the 6 monitors report, which was filed on March the 3rd of this year. The report will include consent decree implementation updates and completed milestones. After the presentation, we will allow public comments and questions. Now I'll return the program over to the monitors, Professors Garrett and Thompson.
Thank you all so much for joining us, and thank you for that introduction, Mr. Turner. And this now marks the 3rd year in this role as independent monitor, reporting to Federal Judge, Chief Judge Rosenthal. We remain honored to have been appointed to do this work. And 3 years in, there's a lot to say about the successes of this consent decree. This was our 6th report, and each report is lengthy, but some of the high-level conclusions that we outline in the report, and there are copies of the executive summary here for people walking in the door, are really striking and exciting. As Mr. Turner described, there are also some milestones to describe and some ongoing work. 3 years in, there's still important work that needs to still be done. We have seen, which is quite striking, a 20% decline in misdemeanor arrests in the time period from 2015 to 2022. You're now under 40,000 misdemeanor arrestees a year in Harris County. It had been about 50,000. It's 10,000 fewer per year. As part of that long-term trend, we've seen fewer people repeat arrested, so lower recidivism. Overall, the repeat offending share is the same, and we've seen lower numbers of people both coming into the system for the first time and coming back into the misdemeanor system, which is all extremely positive. We've described throughout that very quickly when these reforms took place, we saw a really dramatic change in the pre-existing racial disparities in terms of race and who made bond and who was in the jail. That was a really remarkable and striking change that happened early on when the consent decree reforms were adopted. We've been working on larger and more sophisticated causal analyses of these reforms, but they largely just sort of deepen but confirm the basic above-the-line conclusions that we describe in our reports. There have been some really important developments just in these last 6 months that we wanted to touch on, and some new analyses that really are different from things that we've talked about before in our work. One thing that was new in this report is that we had much better identified data on people who were homeless and people who had received a mental health evaluation, referred for one. So it was a better fix on people arrested for misdemeanors who were unhoused or had behavioral health needs. And there was both sort of positive news and then the flip side of that. There has been a marked decline in the numbers of people who were mental health evaluated over the past few years. It had been about a quarter of the misdemeanor system. Now it's just under 20%. Similarly, there had been a decline in homeless people over the past few years. And that said, there's still a large number of people, maybe it's not a quarter, but it's more like a fifth of the population, for example, that have mental health evaluations. Those people are much more likely to have been arrested for trespass, minor theft, the lower level, even among the misdemeanor offenses. Those people are also twice as likely to be rearrested, and they're much more likely to have a bond failure. They are more likely to have their cases not disposed at the end of a year's time, and so there are still many more people than perhaps need to be in these vulnerable populations, and those are the people that are cycling more than anyone else in the misdemeanor system. And there's important work being done to divert people in those populations. We just received a really informative and helpful update on those programs from the District Attorney's Office this morning, and we were really grateful to hear about the hard work being done. There's also been a common theme in some of the cases that we've all discussed among the parties in this case, where we have seen people delayed in terms of release, getting a bail hearing, getting in front of a judge, detained for extended periods of time, which were not necessary, or sometimes it was in violation of the consent decree. And one common theme was similarly people with behavioral health needs, people who are homeless. And there's been important work done by the parties to discuss these problems. We need better systems in place to proactively identify consent decree violations and the types of delays or miscommunications between different actors in the system that can cause these kinds of unfortunate delays in detention that wouldn't otherwise need to happen. Our hope is that 3 years into this, that the role of the monitor will become irrelevant as soon as possible. We'd like there to be systems in place so that the system self-monitors and that we are necessary. And that's the goal of any monitorship, right, is to make monitoring not needed. But we do, unfortunately, view our role as very much needed. And there have been other, challenges that have come to light, which unfortunately didn't come to light without the monitoring, and maybe they should have. We describe in our report some really hard work done, led by Dottie Carmichael, our colleague at Texas A&M University, discovering that through a whole series of snafus, the electronic notifications that were launched with a great deal of hard work over a year ago were not actually being received by people who thought that they were enrolling, that most people who were being enrolled were not actually enrolled. And so that obviously raises real concerns that people thought that they were going to hear about their court dates and they weren't hearing about it, whether they entered their information by hand or they thought a pretrial services or other staffer was going to enter their information in the system. They should have been expecting to have gotten notifications, which the designers of the consent decree thought would be important for people to hear about their court dates, and they weren't getting them. And those errors, had not been detected. And we're grateful that there's work being done to now remedy those problems. But again, ideally, you have a system where these types of things are identified and addressed by the hardworking people of the county. We have some other interesting and new findings in our report, which we could talk more if folks have questions. We describe how cases are proceeding in dockets and case outcomes. We describe how sort of rates of dismissal and conviction have largely remained stable over the past couple of years. We talk about some really interesting work which was done, not by us, but a quite remarkable and important pilot led by the Harvard Kennedy School, a step-down program, where basically each month there were check-ins and supervision conditions were reduced if people were succeeding with the conditions that were in place. And we cite in a report to the study, but the study itself is a really comprehensive and interesting description of the data. But what they described was that over 2,000 people had these conditions stepped down at enormous cost savings. They found that public safety, court appearance, and other measures really did well under this program. And so that raises the question whether this could be embraced more broadly to reduce supervision which doesn't serve public safety and which is unnecessary at real cost savings to the county. On the topic of cost savings, we continue to do our work to evaluate the cost savings under this decree and have some additional data work to do to report something more comprehensive to everyone. But we hope to do that before too long as we sort out some issues with a couple of different data elements. Those are the big overviews. Overall, these findings in this report look a lot like in our prior reports. What we've seen has been very consistent for over 3 years. The main additions, again, were this really important new data pulling out people who had been mental health evaluated or who were homeless, and this unfortunate news about the electronic notification system snafus. Love to turn things over to Sandy now to add some additional observations and remarks if you have some, and
Sure.
and again, we really look forward to your questions.
Thank you, Brandon. Again, I'm Sandra Guerra-Thompson. I'm a professor at the Sandra Guerra-Thompson, professor at the University of Houston Law Center, and my role is as deputy monitor. I'm kind of the Houston contact for the monitor team. And just to remind everyone, the major change brought about by the consent decree had been adopted by Rule 9 in the courts here. And what that does is essentially allow for most people who are arrested for misdemeanors, the lower level offenses, to be released without having to pay money. Cases that may involve a public safety risk are carved out of the rule. Those cases are handled differently. So the rule incorporates concerns about public safety into it. And again, to reiterate what Professor Garrett just said, we're finding that this is working, right? That there's a lot of cost savings for the people of Harris County, both the taxpayers as well as the individuals who might otherwise have had to pay money unnecessarily to get out of jail. And they're no longer having to do that. And they're not having to go through the booking process, staying in jail overnight and this kind of thing. So it's a really huge shift in how misdemeanor cases are being processed. And it doesn't happen without a lot of work. One of the reasons that we agreed, the primary reason I think we agreed to do this work, is that we knew we were going to be stepping into a position where we were working with cooperative parties. And so there has been so much work done by so many agencies. Professor Garrett alluded to the Harris County District Attorney's Office and their mental health diversion group, which is a big part of the population that would normally be going into the jail, which are no longer having to do that. Many of these people are getting the help they need and saving taxpayer dollars, as well as because of the intervention they're getting, they're recidivating at a lower rate, right? So they're not reoffending, they're not coming back into the system. And they have other pretrial diversion programs as well. The Office of Justice and Safety has done enormous work on this project and put up a bail dashboard that makes a lot of the data that we're talking about accessible to the public, to researchers, to the media. This was not happening before the office started to take on these challenges. And I think this kind of transparency is unusual, especially for such a large jurisdiction. So we're really excited about that as well. We have representatives here from the Harris County Criminal Courts at Law, the Sheriff's Office, the County Attorney's Office. All of these folks are working together and making enormous strides in improving things. But in addition, we've been really grateful for the cooperation we've gotten from the Houston Police Department, which is not a party to this litigation, but has met with us, has provided access to their data, which is really informative and really helps to show the whole picture of what's going on. In addition, the Public Defender's Office has been very helpful in trying to work through some of the issues that Professor Garrett was talking about. How do we expedite processes so that people who are eligible to be released can be released more quickly. We've had conversations with Harris Health, who does the health work, that provides the health services in the jail. We've talked to the folks at the Harris Center who do the mental health diversion that the district attorney's office is working on. And all these people are really on the same page and trying to, to bring about the improvements that, because it's an enormous system, trying to get everything to work together is not easy. But we are seeing a lot of progress. So thousands of people who would have spent days in jail and who did spend days in jail before these changes are no longer having to do that. Their lives are not being wrecked, and the cost to taxpayers is great, is much reduced. The cost savings are great. And, the community has been rightly concerned about things like backlogs. We know that there were backlogs created during Hurricane Harvey, and that just as the county was coming out of that, we had COVID. But, we're getting reports that backlogs now are reduced to pre-COVID levels in the misdemeanor section. So that's really good news too. And that's again the result of a lot of work that's being done by various agencies working together. I would just add that, as part of my job working with the community, we've benefited greatly from having input from a lot of different sectors. We've worked with service providers for the homeless and mental health providers, as well as advocates for survivors of domestic violence, immigrants. We have law enforcement partners who advise us. Advocates for women and service providers for women who are victims of sex trafficking, and who come into the criminal system through that kind of activity, as well as civil rights advocates. We're grateful for the assistance we've had from the Greater Houston Coalition for Justice, the Criminal Justice Coalition, the NAACP, and the Texas Organizing Project in particular, although there are others that I'm sorry if I'm forgetting. But it's been a real community-wide effort, in other words. Lots of agencies across the county and the city of Houston working together. And I would just add finally that I think we should be rightly proud of the work that's been done in Harris County and the city of Houston to address the problem of homelessness as a general matter, outside of the criminal justice system, because those efforts that have gotten national attention really are benefiting the criminal justice system as well. And so, I think we have a lot of expertise and resources that have been devoted in the last couple of years in a big way to try to address that problem, and that's redounding to the benefit of the criminal justice system as well. So I think that's about all I have. So I will just turn it over to whoever's next on the agenda.
Okay, next we'll hear from our county attorney's office, Mr. Seth Hopkins.
Thank you. Good afternoon. I'm Special Assistant County Attorney Seth Hopkins. The county attorney is committed to helping to work with our stakeholders to ensure that we have a constitutional, transparent bail system and that it also meets the needs of public safety. Our office provides legal representation, contract support, contract management to help our departments and county officials comply with the consent decree. One of our current projects is to help the stakeholders comply with Section 7 of the consent decree by advising them as they incorporate recommendations from the National Association of Public Defense into the county's Indigent Defense Plan. We're also helping our stakeholders comply with Section 55 of the consent decree by working with them to develop a plan to improve misdemeanor appearance rates at court hearings. And that's required a lot of work from our stakeholders. The district clerk's office, who's present at the meeting, we thank you very much for your efforts. The court administration, we thank you for your efforts as well, and the sheriff's office. A lot of stakeholders came together and did some really good work to make that happen. That plan is in the final negotiations with the plaintiffs right now, and we hope to see it very soon. We look forward to continuing to work with everyone, with our stakeholders, to help the county comply with the consent decree, and we look forward to seeing everybody at the next public meeting. Thank you.
Okay, thank you, Attorney Hopkins. Next, we'll hear from the Harris County Sheriff's Office, Major Patrick Doherty.
Good afternoon. My name is Major Patrick Doherty. I'm representing the Harris County Sheriff's Office. The Harris County Sheriff's Office is responsible for the intake and processing of all misdemeanor arrests in Harris County from all agencies. The law enforcement officer makes the arrest. They'll bring them to our facility. During the charging process through the district attorney's office, we will process them through the building, and a large portion, as the monitor said, will be released on what we call a general order bond through a pretrial release bond without staying in the jail. There are a few carve-outs for public safety reasons that will have to go to a magistrate, and sometimes we'll have to stay in jail, but the large portion of the misdemeanor arrest will basically be charged and be released in the same day. And it's our responsibility to ensure that they're done in a timely manner, with the DA making the charge, with the pretrial services doing their part of the process, and us getting the paperwork and getting them out. We do hold a responsibility also to watch the time limits, and if there are certain times where the time limits get to the end, then we have to take certain actions to follow the consent decree. We look forward to working with the monitors to do our part of the process in holding up the consent decree.
Thank you, Major Doherty, for the update. Next, we have Judge Genesis Draper, Harris County Criminal Courts at Law.
Good afternoon. My name is Genesis Draper. I'm the judge of Harris County Criminal Court at Law Number 12. I am also the presiding judge for all 16 criminal courts at this time. I don't have a ton to add. I will just say, one, I want to thank the monitors for the work that they have done to keep up with the compliance, but also the progress of the consent decree. Additionally, to thank the justice partners that we work with to make sure that we all remain in compliance. There are individuals and departments that are not parties to this lawsuit that have really leaned in to make sure that we remain in compliance and that the county has constitutional bail practices. You know, I think it's important for everyone to remember that we operated for years and decades with an unconstitutional system, really without challenge. And so it's been quite the feat to undo that, but everyone has taken that role seriously. We remain committed to the consent decree and the continued work necessary to, one, remain in compliance, but also to make sure that our system adjusts to this new normal. Some of the things have been mentioned, making sure that individuals who do remain detained are seen by the judge quickly so that determinations can be made as to whether or not any changes in the bail status need to be made. You know, it was mentioned about the backlog, and so I think it's worth noting that even with the commitments we have with the consent decree, which are great, we have continued to work on the backlog, and I think our clearance rate, at least as of this month, hovers over a little over 125% on average, which means that we are clearing more cases than we're taking in. Additionally, you know, cases are considered backlog after 180 days, and there are significant hurdles within the Harris County justice system to really meeting those metrics. But we continue to work on that, and even with those hurdles, at this time, less than half of our active pending cases are backlog cases. And we have chopped into that backlog, cut that down by about 31% here recently. And so there is progress being made. We continue to work with not only the individuals here at this table and in this room, we also have the Office of Managed Assigned Counsel. The attorneys that work with that office represent a large portion of the people that are in our jail population, and so we do want to work with them to make sure that they are equipped with the information necessary to advocate for their clients under the rules required by the consent decree. Additionally, there's the issue of jail population. We can hardly have a conversation these days without discussing the significant issues with our jail population. And so, I remain extremely proud of the work that has been done through the consent decree and our decision to settle, because in doing so, we didn't anticipate that we would have COVID coming up where everybody was scrambling to see who could be released. Well, at that time, we were already not detaining people that should not be detained. And we could not have seen that we would have a jail, bursting at the seams. But the county courts have, for years at this point, taken a really proactive role in making sure that we are not unnecessarily detaining people. And it does allow us the time and capacity to take an individualized look at people detained to see whether or not there are appropriate conditions of release, so that we can do our part to have a positive impact on the issues with the jail population. So I say all that to say that there is plenty of work left to be done, but there has been plenty of work done. And I think the people at this table in the room and the community who has really been patient with learning more about this process and what it means to run a constitutional bail system, I think that those efforts should be commended, and I look forward to working with you all moving forward. Thank you.
Thank you, Judge Draper, for your remarks, and also the panelists for their hard work, support, and partnership. It's greatly appreciated. We'll now turn it over to the project manager, Ms. Breon Cummings.
Hi, so the live stream I think is down. So I'm not sure if anything is down. So I haven't got any questions virtually that anyone wants to ask. But if there are any questions in the room that wants to be brought forth, you can bring them at this time.
My name is Roger Bridgewater, and I'm with Tom Ramsey, Commissioner's Office. I just had a question for the county attorney. With the Davis versus Dallas decision, what, if any, impact that had on our O'Donnell decree?
We're not prepared to comment at this point. At some point, there may be litigation that determines that, but at this point, we don't have a comment on that.
Okay, thank you.
If there are any more questions, you're free to come.
Good afternoon, Marilyn Burgess, Harris County District Clerk. I'm just curious of where we stand on the myharriscountykcase.org or com, I don't remember which it is. We built the interface so that it could link directly to our site, which has all the data already there, but built the interface where it would be more accessible, user-friendly for a non-attorney to find the information they need. But as my understanding is, it's still not been turned on, and I'm curious where we are on that.
That's a great question. And first of all, thank you so much in your office for your work, particularly Tracy Hopper, who's been wonderful with. We have prepared that as part of a comprehensive plan, Section 55 plan, we call it, our non-appearance plan. It's got to be approved by the monitor and the plaintiffs. Been going back and forth with the plaintiffs, and we think we're very close to having it. The next step is that once it's approved, court get the money, and we move forward. I hope that answers your question. Soon. We really hope it's soon. And the monitor, let me also say the monitor has been wonderful, and we really appreciate his support.
Well, and it's a really impressive plan, and we could certainly see readily the hard work that your office did and that so many stakeholders did to put together such a thoughtful and really holistic approach to trying to make the process more transparent and understandable and easy to navigate for people. It's so important, and so we just couldn't be more impressed with the hard work that you all put into this.
I know I've said it 3 times. It's worth saying a 4th. We're very grateful to your office. Thank you all for your work.
My name is Gregory Gomez. I just had a question as folks were talking about the misdemeanor cases and how when public safety is on the line, So can someone describe, whether that's like a static rule, like for a certain type of misdemeanor, or like more dynamic, and like what the decision-making process is for keeping folks or releasing folks?
Sure. So Rule 9 and the consent decree set out 6 categories of people arrested for misdemeanors for whom there is no, general order bond available. They are, they receive a bail hearing, and so those include repeat DUIs, certain types of domestic violence and assaults, violations of bond, violations of parole or other supervision. One advantage of the way the consent decree sort of triages cases is that there are far lengthier hearings for those cases that raise important public safety concerns for those issues to be aired. Bail hearings, when we certainly saw some of the videos and some of the data, sort of pre-consent decree, they were often 30-second affairs, 45-second affairs. There's a much more robust discussion of what needs to happen and whether the person poses a public safety risk, if there are going to be conditions, what are the right conditions to ensure public safety, should this person be released. Like Judge Draper described, these hearings are more intensive now, and there's representation by counsel, which had only been piloted before the consent decree. And so the goal is to have much more serious bail hearings in misdemeanor cases for the misdemeanors that matter. Again, that wasn't our doing. That was a lot of hard work by the parties in designing this consent decree and in crafting Rule 9. But that's the way. So it's not a. I guess the way that there is an additional layer of public safety consideration is at the bail hearing itself. The standard that is considered is, is there clear and convincing evidence that there is a threat to the community or a threat of non-appearance? And so there is a public safety focus standard as well at the bail hearing itself. But there's also sort of a public safety related thinking went into the design, where here are these classes of offenses or violations of supervision or conditions. These are the people that we need to see in a bail hearing.
And if I could just add, to add to that, there are much more robust hearings had in that we take a lot more consideration for people that will be released, what type of conditions need to be set. It was pretty well known that previously, if you could post a surety bond, you could avoid conditions. So you post your surety bond, you get out, you come to court, and you could avoid conditions that may be appropriate because you posted a surety. And so often when we first entered into the consent decree and we were saying, okay, I think this is appropriate for a personal bond, people were like, oh no, I don't want a personal bond because I don't want to be supervised. And so now we take an individualized look at each case, that even if we were not the judges who originally set the bond, and what conditions are appropriate for the people that are released.
The floor is still open if there are more questions, and the stream is working now, so I apologize for all of you all online. I will say this: we are having another public meeting, which is all virtual, on April the 11th at 6 p.m. So if you were not able to get all of that information at this time, we will have another meeting in another couple of weeks where you'll be able to ask questions virtually, and we will be able to respond. All right. Well, if there's no questions in the gallery, that concludes our meeting for today. Thank you all again for all of your support in implementing the consent decree, and all of you all that joined us here today in the courtroom. We appreciate it. Have a good afternoon.